Ladies and gentlemen, can you hear me? Can we start? And we have to start because we have terribly run out of time. The timetable has already exploded, which is not our fault. Let's start very quickly. Just a few words on my person to introduce myself. As you might remember, I am now a full member of the Institute of Legal Studies in Warsaw, but originally I'm sort of a foreigner. So we are definitely starting to create an international team in our institute. So let's start with our issue. I welcome you to panel 4 on the case of Crimea and implications of non-recognition of unlawful situations. Yeah, we have, when the creators of this program thought about these issues, they thought about the conflict between constitutive and normative theories. Are they still relevant? About the impacts of non-recognition, what is the role today? And last not least, what does it mean to Crimea? What recognition will we be talking about? Recognition of the so-called elections, referendum, recognition of transitional political institutions, or the consequences of annexations? We have many questions, and I'm very optimistic that they will be answered by our panelists and also by our discussants. And I may now give the floor to Enrico Milano, who is Associate Professor of International Law at the Law Department of the University of Verona in Italy. And he has been, we can say that he is a real expert in the subject of non-recognition, particularly by publishing a book on unlawful territorial situations in international law, issued in 2006. And I think this should be enough. Just start very quickly, and please don't exceed your time. Thank you. 15.
Good morning, everybody. Let me first thank the organizers of this very timely and great event, and thank them, and in particular thank Władysław Czapliński for the great hospitality. Now, let me first define the scope of my analysis. I think today perhaps my presentation will be the more theoretical and conceptual, and probably also the most boring among the ones you're going to hear, because I'm going to try to systematize the concept and the doctrine of non-recognition, because this is a doctrine that, you understand, it is very often employed with different meanings and with different understandings. And I think, as a matter of fact, after a careful analysis of the practice of the International Law Commission and of courts, I think we can identify 3 prevailing accounts of non-recognition that I will call the normativist account, the communitarian account, and the realist account that construes non-recognition as a sanction. Now, in a few words, what do I mean by non-recognition? When I refer to non-recognition, I refer to non-recognition as a legal obligation, and we should distinguish non-recognition as a legal obligation from recognition of governments and recognition of states, which is in general a discretionary act. It shows the political willingness of the state to enter into certain relations with a certain government and a certain state. So here we are dealing with non-recognition as a legal obligation. And going straight into the case of Crimea, then to go back to the theory of non-recognition, with regard to Crimea, we have seen a consistent and quite significant practice of non-recognition by states, certainly mainly Western states, but also by international organizations, including the United Nations, the European Union, NATO, and also the OSCE through a resolution which was adopted by the Parliamentary Assembly. Now, mainly it has been a formal non-recognition of the referendum and of its immediate consequences, including the incorporation or annexation, whatever we want to call it, of Crimea by Russia. But we have also seen instances of a more comprehensive policy of non-recognition, including non-recognition at the European level through, for example, Regulation 692, which imposes a ban on the imports of goods originating from Crimea and not being licensed and certified by Ukrainian authorities. I've also come across, for instance, a decision by Eurocontrol not recognizing the provision of air traffic services by the new Crimean authorities, but I've discussed that with Professor Stadtmeier. I mean, this is really, I have seen only a press statement, and we should look more carefully at that decision. It seems to me that could be a form of implied non-recognition. More importantly, we should recall paragraphs 5 and 6 of the resolution adopted by the General Assembly on the 24th of March last year, which calls upon states not to recognize any alteration of the status of the Autonomous Republic of Crimea and of the city of Sevastopol, and to avoid any action or dealing that might be interpreted as recognize such altered status. Now, the doctrine, as I said, of non-recognition has been generally recognized in practice by the LC, by international courts and tribunals, but what I want to submit, the three questions remain to a certain extent contested. The first one is whether the non-recognition is really mandatory under general international law. The second one is what is the legal basis, if there is such an obligation under general international law, what is the legal basis? And thirdly, what is the scope of application of the obligation of non-recognitions? And what I'm going to submit today is that the answers to these questions vary at least to a certain extent, according to which one of these three prevailing accounts you espouse. The first approach is what I could identify, what I have identified as a normativist approach. This is the approach that was famously proposed by the International Court of Justice in the Namibia advisory opinion, in which the court held that the objective illegality of South Africa's presence in the former mandate was opposable erga omnes, including against non-member states of the United Nations, which were under a duty to avoid any formal recognition of South Africa administrations, but also implied forms of recognition like the entering into international agreements with South Africa concerning Namibia. The court in that occasion also spelled out an exception, which is known as the Namibia exception, which has a humanitarian gist, but this is something that will be discussed in a further presentation. Now, the court, this normativist approach to non-recognition has been recently confirmed and upheld in Judge Higgins' separate opinion in the legality of the whole case. Judge Higgins, in that opinion, contested the use of erga omnes obligations to justify the duty of non-recognition that we find in the advisory opinion, and said that there was no need to resort to a controversial notion and contested notion like that of obligations erga omnes to justify an obligation of recognition with something that is considered objectively illegal. Now, according to the normativist approach, non-recognition is mandatory, is obligatory under general international law, and its scope of application is very broad. if we were to identify what is the legal basis for such obligation, we would identify in the principle of ex ignura jus non oritur. We can consider it a general principle of law under Article 38 of the ICJ statute, by which an international wrong cannot be the source of a legal right or of a legal title. The normativist approach also finds explanation in the context, in the content, of primary norms protecting the subjective rights of states or peoples against forcible territorial changes. Such subjective rights, I repeat, the subjective rights are opposable erga omnes, and the practice of states and international organizations has, for instance, come to accept as a corollary of the prohibition of territorial aggressions that no states shall recognize the results of a territorial acquisition produced through resort to the use of force. It shall not be recognized as lawful. This is what we find both in the General Assembly Declaration on Friendly Relations of 1970 and in the General Assembly 3314 on the definition of aggression. Here it is important to stress the two words as lawful, because the insertion of these two words, not to recognize as lawful, was very much contested during the preparatory works of the 1970 Friendly Relations Declarations. Because on the one hand you had the non-aligned movement, the thought that non-recognition should be simply non-recognition, so states should avoid any dealing with the wrongdoer, and on the other hand you had the position of Western states thinking and arguing that only formal recognition of the legality of the authority should be avoided. And in the end, in the wording, the position of Western states prevailed. So here we already find an inherent tension between the two legal bases. The legal basis, ex ignura jus non oritur, arising out, justifying the objective illegality, justifies a more comprehensive duty of non-recognition. If we take the Western approach, non-recognition as lawful, de facto relations, de facto dealings may be to a certain extent justified. And state practice tends to be more lenient to the Western approach. However, there is another big problem concerning the doctrines of non-recognition, and is the question of determination of illegality. Who decides, who determines whether a certain situation is objectively illegal? We know that we don't have a lawfully delegated authority that may decide with legally binding effect, apart from those rare occasions where the Security Council determines the legality and imposes certain legal consequences, including non-recognition, on the basis of its Chapter 7 powers, or on the basis of an extended interpretation of Article 25 according to the theory of implied powers. Now, if we go to the case of Crimea, this point is very important. Why? Because we have a Security Council resolution which was vetoed by Russia and did not pass. We of course have a determination by the General Assembly, but we know that the General Assembly does not have the power to impose legal obligations upon member states. It may have a certain legitimacy because it is representative of the whole of the international community, but it cannot impose obligations. Now, the second approach is the communitarian approach. The second approach is the communitarian approach, which was endorsed by the International Law Commission through Articles 40 and 41, which have been shown previously by my friend Maurizio Arcari. So, according to the LC, we have secondary norms providing for certain obligations which constitute an obligatory reaction to grave violations of peremptory norms, including territorial aggressions. And the more minimalistic obligation that we find in Article 41 is that of non-recognition, again, of the legality of the situation. Now, what is interesting is that the ILC, despite the fact that it talks about not to recognize a certain situation as lawful, it says that in the scope of application of the duty of non-recognition, we also have implied forms of non-recognition. So in terms of scope of application, it goes back to the scope of application, very extensive, that was spelled out by the ICJ in 1971 in the advisory opinion. Even with the communitarian approach, when non-recognition is a reaction of the international community as a whole to the violation of a fundamental norm protecting a value of the international community, even here we do not have an authoritative system of determination of the existence of a grave violation of a peremptory norm. And so one is left again with the impression that it is up to each state, individually or collectively, to decide whether there is a serious violation of a peremptory norm, and then we have also the obligation of non-recognition. Third approach, non-recognition as a sanction. Here the approach is very different from the previous one, because in this third approach, non-recognition is not mandatory under general international law. There has to be a determination by the Security Council and an imposition of legal obligations by the Security Council. There is no automatic trigger. So the obligation is not mandatory under general international law, but it is conditional upon a binding decision-making by the Security Council. And here, the view of non-recognition as a sanction was endorsed by the ICJ in the East Timor case, because in the East Timor case, the court said the Security Council, the General Assembly, had condemned the invasion of East Timor, but they did not impose any obligation of non-recognition upon third states, including Australia. And so here there is a gap between what is said in Namibia and what is said again in 1995 in East Timor. Now, 2 minutes. Let's assess the practice concerning Crimea. I think in the practice concerning Crimea, we have an indication that all three approaches have been, to a certain extent, consolidated. Because on the one hand, you have a recurrent emphasis on the protection of subjective rights of Ukraine. We do not recognize the annexation of Crimea because Crimea has a right to its territorial integrity. And if we recognize that, we are breaching the territorial integrity of Crimea. Secondly, we have an invocation of a general interest of the international community. So there is a value, there is a norm belonging to the international community that has been breached by the conduct of Russia. Also, we see that non-recognition is construed as a sanction. It is a way to impose certain costs, and if you like, it is again the more minimalistic sanction together with all the other sanctions that we have seen. In sum, I arrived to the conclusion. I think I have another 30 seconds.
No.
No? Okay. Sorry, Chair. My conclusion is that the practice related to Crimea is an important practice pointing to the consolidation in the theory, in the doctrine of non-recognition. On the other hand, there are still certain indeterminacies there, especially concerning forms of implied recognition, forms of de facto relations with the wrongful administrator of a territory, and then there is a problem of determination. Here, again, we do not have a resolution by the Security Council, we have a resolution by the General Assembly, and then the question arises whether obligation, especially if we take the third approach, whether the obligation of non-recognition is really mandatory. Thank you for your attention.
So, thank you. Thank you, Mr. Milano. And now we continue right away with Professor Oeter from Hamburg University. He will introduce himself, and then you have the floor, yes. Stefan.
Thank you very much. Yes, Stefan Oeter. I hold the chair of Comparative Public Law, Public International at the University of Hamburg, and well, throughout my decades of career, I've developed rather varied interests, but what interests me most in the last years is what I would call theory of international, at the interface of international relations theory, and in particular also issues of self-determination, secession, recognition, where I've written a series of pieces in the last years, and what I will tell now draws a bit upon that. My starting point is relatively simple and can link to what Enrico said, the principle of non-recognition of situations arising from unlawful acts, and in particular from violations of peremptory norms like the prohibition of the use of force. That's now a firmly established principle under current public international law. I can only briefly mention kind of the documents which corroborate that. We've talked on the Friendly Relation Declaration, the resolution on the definition of aggression of 1975. We have the ILC draft articles on state responsibility, on which we had some remarks by Maurizio earlier this morning. We have the jurisprudence of the ICJ, which spells out on that, the advisory opinion on Namibia, the case concerning East Timor, the Wall advisory opinion, and we have a certain practice of the UN Security Council that started with the Rhodesia case, then the various resolution practices towards the various Bantustan cases, the Turkish Republic of Northern Cyprus, where we have Security Council resolutions. So there were also non-recognition clauses in Security Council resolutions on the Iraqi annexation of Kuwait in 1991. One must say the Security Council is not completely consistent. There are cases which would deserve the same treatment, where we have no resolutions of that kind. Quite naturally, if you look to the composition of the Security Council, it's the occupied territories and the annexed territories in Palestine. We have no resolutions on Western Sahara, and we have no resolution on Crimea. The reasons are obvious, so we shouldn't take these inconsistencies not too seriously as a matter of law, because it's simply a matter of politics, this inconsistency. But I said it's a firmly established principle, but I agree with Enrico that we have no real agreement on what it means in detail. And this, I think, and you shed light on that. The most difficult questions are, how far do we have a mandatory obligation not to recognize the results of unlawful acts in detail, ex injuria non ius oritur, or to what degree that's an option of let's say, as a kind of sanction, as you described it, as a third. So that's, I would say, there is not a clear-cut case to say we cannot argue simply it's the one or the other. I myself must say I have a certain sympathy for the kind of comprehensive approach of saying that's a logical result as a mandatory obligation, but state practice is not really in conformity with that, one must really say. Even in the cases, and what I will now try is to shed some light on the question, what does that mean in detail if we say an obligation of non-recognition? We have quite some kind of some case material from state practice on that, but as I would say, it's not really consistent if you construe it as a mandatory obligation, because states sometimes do it, sometimes they don't do it, and that's again also a matter of policy, but there we have definitely a problem. So what does it mean if we say there's a mandatory obligation of non-recognition of unlawful acts, of the consequences of unlawful acts, in particular of violations of peremptory norms? I think the first issue is, and we are here speaking on territorial issues, it's a prohibition to conclude a treaty which implicitly recognizes the territorial sovereignty of the new kind of administrating power, because that would recognize the unlawful act if you would treat him in a treaty as a sovereign. That means no demarcation treaties on boundaries, and not also land boundaries, but also zoning in the sea, no demarcation of exclusive economic zones, no recognition of exclusive economic zones in any kind of international agreements, including joint exploitation agreements. That was the East Timor problem. Which means, and we have some material from the Cyprus case, it creates an obstacle for the exploitation of the resources which are in the exclusive economic zone, because it means no one of the big international corporations in the oil and gas business will invest billions of dollars in an oil field when there's no legal security who may grant the concession on that. This works at the moment in the case of Cyprus because there's complete insecurity about who can act in the case of Cyprus, and the same will happen in the case of Crimea. Perhaps some Russian enterprises will try it, but there will and should be no international consortia investing in that, because it's quite clear that Russia, in legal terms, if you follow that approach of non-recognition, is not competent to grant concessions for any claimed exclusive economic zone, because in essence it's an exclusive economic zone of Ukraine. The same, that's the first type. The second is the non-applicability of treaties with territorial clauses of application. I would like to illustrate that by an example where I was involved already in the 80s. This was an internal German law proceeding before the Social Security courts, ending up before our highest Social Security court, the Bundessozialgericht, which was on the application of the bilateral German-Israeli Social Security Treaty, where under certain conditions Israeli citizens residing in the state of Israel have a right to get pension or to get social security pension benefits from the German pension scheme, which is mostly for Jewish people originating from Germany. And there was a quarrel on a person residing in Eastern Jerusalem. And this quarrel was also on the Namibia exception, on which we will hear later. Finally, the Bundessozialgericht, the Federal Security Court, decided, well, this person is not residing in the territory of the State of Israel. He's not covered by the rights of that treaty, and since he's residing in occupied territory, Israel claims that to be its own territory, but it's unlawfully annexed. It's not the territory of the State of Israel, so the treaty does not cover that situation. And we will have the same with double taxation agreements, which also usually have this clause, so a natural person or enterprise residing on the Crimea will not be covered by the double taxation agreements, who will not privilege from the arrangements in their social security agreements I've already mentioned. This goes for all types of cooperation agreement. Let's take a case of a crime committed in Crimea, then with the question, let's say, extradition. Is there, under an extradition treaty, a right of Russia of having that person extradited? Usually there are territorial clauses in these treaties, and then you probably must argue, well, Crimea is not part of the territory of Russia, so there is at least no obligation to extradite such a person, because that situation is not covered by the extradition treaty. We have another direction where that works. That's transport arrangements. That's not mandatory, clearly not mandatory. That's the question. What about airports, ports in the annexed territory? That's to a certain degree up to the former or to the de jure territorial sovereign, because the territorial sovereign may decide which airports are open to international traffic or are closed to international traffic, and the same is true for ports under the law of the sea regulations. So the de jure territorial sovereign, in that case Ukraine, may close airports and ports for international traffic, and the other states are bound to obey to that decision, because under international law that's still the territorial sovereign, and non-recognition means Russia has no say in that, because it doesn't have territorial sovereignty over these territories. Some remarks on international trade. there's the problem, what about tariff concessions under the GATT? I would say in a comprehensive non-recognition policy, they do not apply to goods from the annexed territory, because that, again, is not a good originating from that state, in that case from the Russian Federation. And this usually comes to the surface with the problem of, let's say, certificates of origin. What is the origin of a certain good? This is not a new problem. We have had this quarrel with the occupied territories of Palestine, where Israeli authorities used to issue certificates of origin for goods originating in the occupied territories as goods made in Israel. And there's a big quarrel between the European Union and Israel on not recognizing these certificates, saying that's not made in Israel because that's not from the state of Israel, that's from the occupied territory, so that may not benefit from the free trade arrangements. The same, I would say, is true for investment protection. A foreign investor may not rely on an investment protection granted in a treaty with the illegal occupant. So somebody who would now invest in, well, Russia is not that keen on, let's say, signing international investment treaties anyway, but that's more a hypothetical case. But in other cases, that might work out. If you invest in an annexed territory, you afterwards cannot claim my investment is protected under the treaty because it's not an investment in the territory of the state concerned. Here, one short remark on a very, let's say, difficult issue with which I've dealt in the last year. This is corporate social responsibility, which this is coming up more and more concerning the occupied territories of Palestine. The problem, let's say, as a multinational corporation operating economically in an annexed territory or in an illegally occupied territory, to what degree may you participate in the exploitation of that territory? May you invest in exploitation of natural resources? There are, at least if it's a formally occupied territory, there are good arguments from the Fourth Geneva Convention that this is prohibited. May you participate, this is in the Israeli case a big issue, may you participate in transfer of population by assisting in building settlements for newcoming citizens of the illegally annexing state. Isn't that a participation? Because that's clearly in itself an international crime under the Rome Statute. Isn't that a participation in an international crime? I've played that through, and my colleagues from international criminal law have told me it doesn't even matter whether the main actor is covered by the jurisdiction of the International Criminal Court if the kind of participating actor is covered by that under the personality principle, that might suffice. So for enterprises, we might come in serious problems here. The last remark, I'm assuming that if it's illegally annexed, it's in a way an occupation, an illegal occupation. The administering power is an occupying power. The repercussion of that is that at least one set of international legal obligations applies, and that's human rights, and that's clear now in the jurisdiction of the Strasbourg Court, that occupation, Alskany case of the European Court on Human Rights, occupation clearly is a case of jurisdiction, even if it's in a completely other part of the world, which is not true for Crimea. So that's a case of jurisdiction, and even as an illegal occupant, you are bound by human rights when you exercise jurisdiction on that territory, which means that the occupying power should not be able to escape its human rights obligations, and the residents of the territory may profit from that. My conclusion, we have a firmly established principle of non-recognition, which has a number of consequences throughout a wide array of public international law. It's not that clear whether that is always mandatory, but it's at least if you try as a state to do that comprehensively, you end up with quite a number of consequences which you have to draw, and I've tried to let's say to draw a bit a picture of what that might mean. Thank you very much.
Yeah, Thank you very much, Stefan. He's an example for us all, sort of a best practice to keep up with the time. Thank you very much. I give the floor to Professor Hamamoto, from Kyoto University, and maybe you like to say a few words on yourself. Please start.
Thank you very much. My name is Shotaro Hamamoto, Professor of International at Kyoto University. I'm here probably because I am a member of the Committee of the Recognition and Non-Recognition of the International Law Association, headed by Professor Chaplinsky. And since the committee has been created, I have become a regular visitor to Warsaw, and I'm really grateful for that. Well, my presentation is about exception, but actually, as a matter of fact, 90% of my speech have already been covered by my previous speakers, so I can be extremely short. Well, I'm supposed to deal with a sort of very practical questions. Some of you may be familiar with this problem of the artifacts or art objectives in the Netherlands or Amsterdam Museum. A museum called Allard Pearson in Amsterdam organized, hold a exhibition of Crimean treasures or something, and exactly during the period of exhibition, the annexation took place. After the exhibition, of course, the Allard Pearson has to return those art objects, but to whom? Is it possible to return it to the Crimea Museum, or should those objects be returned to Kiev? The museum was not able to decide on it, so they decided to do nothing. Then the Crimea Museum filed a suit against the Amsterdam Museum to return the objects to them. And the Ukrainian government joined. Now the proceeding is pending before the Amsterdam court. I hope that the very able Dutch judges will render a very interesting judgment. They're very familiar with international law, of course. But in any case, the case is pending. And we are supposed to deal with these kind of questions when we talk about non-recognition. And I do not pretend to be 100% original in this issue. We have lots of discussions, lots of papers, including the committee report. And if you're interested in the general backgrounds, please refer to those papers. So my presentation is very simple, simply structured, principles and examples, but examples have, as I said, already been widely covered by my previous speakers. Let's look at the first of all General Assembly resolutions, which does not impose any obligation to non-recognition. It is true, but if any state is under obligation not to recognize, and the state is supposed to refrain from any action or dealing that might be interpreted as recognizing any such altered status, which means that any state which is under an obligation not to recognize is supposed to refrain from any action or dealing that might be interpreted as recognize any such altered status. So it can take some action or some dealing. And what's those action or dealings? And the Namibia exceptions, of course, we now know familiar with this. The International Court of Justice stated that we can take some measures, we can make some dealings with the South African authorities, although we do not recognize the South African administration over Namibia. And the European Court of Human Rights confirmed this principle in the well-known Reitz judgment. I suppose that many of you are familiar with this. It is quite understandable because even under the very classic law of military occupation, military occupants can take certain measures. Military occupants do not have a territorial title, but it exercises certain power to administer the territory in order to maintain the peace and security of the part of the land that occupies. Therefore, it is absolutely normal that we can recognize certain measures. But what kind of measures, practically speaking? We often say that we should not recognize the official authenticity or the official nature of the documents issued by the unrecognized entity, but to a certain extent, many states, I here quote only recent practice of the United States, many states recognizes official documents issued by an unrecognized entity or unrecognized government or unrecognized authority in order to protect the lives of local people living there. Of course, we do not recognize the government or the authority over those people, but in order to protect those people, we have to somehow recognize some acts of the government to a certain extent. But which does not necessarily mean that we have to recognize anything. And I think Stefan referred to this Anastasiou case, although he didn't name it. The Cyprus, this is about the Turkish Republic of Northern Cyprus, and the European Court of Justice decided that the member states of the European Community should not recognize the authenticity of the documents issued by the Northern Turkish Republic of Northern Cyprus. I'm sorry, but that is probably because I think. This is my personal opinion. This judgment does not devastate the local population living in the northern Turkish Republic in Northern Cyprus, so-called the Turkish Republic of Northern Cyprus. In another judgment which the court rendered 6 years later, in 2000, which is called Anastasiou II, and the court held that it is possible to import the products produced in the Turkish Republic in Northern Cyprus via Turkey. First, you have to export the product to Turkey, and from Turkey to European Community. If you take this way, there's no problem. So the local people living in the Northern Turkish Republic of Northern Cyprus can export, as a matter of fact, their products to the European Community via Turkey. That's what the court stated. Well, concerning the application of treaties, double taxation treaty mentioned by Stefan poses an interesting question. And this is a very interesting example that I'm showing you. This is a treaty concluded between France and Indonesia right after the Indonesian invasion of East Timor. And France did not recognize the annexation of East Timor to Indonesia. And at that time, this treaty was concluded. And this treaty says France means blah, blah, blah. And at the same time, Indonesia means that the territory of Indonesian Republic as defined by its domestic law. And at this time, the East Timor was the 27th province of Indonesia. Therefore, according to the domestic law of Indonesia, East Timor was part of Indonesian territory. Well, does this mean that France officially recognized the incorporation of East Timor into Indonesia? I do not think so, because the treaty clearly provides that Indonesia, in the sense of domestic law. Secondly, and probably more importantly, even under the military occupation, military occupants can impose and collect taxes in order to, when it is necessary to maintain the peace and security of the land that they occupies. Another example is human rights treaty. Of course, everybody knows here in Europe that Turkey was held responsible for what they did in the Northern Turkish Republic and the Northern Cyprus. And by doing this, the European Court of Human Rights did not recognize the incorporation or the independence of Northern Turkish Republic and Northern Cyprus, simply because the treaty in its Article 1, the convention in its Article 1 provided that states has an obligation to protect human rights within their jurisdiction, not the treaty, but within their jurisdiction. Therefore, out of the territory, you can be obliged by the treaties. Well, what about other treaties which provides that the states are obliged to do this, to do that within their territories? That makes the things a bit complicated. I think this is an interesting example, the Convention on the Civil Aspects of International Child Abduction. Ukraine is party to this convention. Russia is party to this convention. Japan is also party to this convention. Suppose that somebody from Crimea and the Japanese got married, and then they have a child living in Japan, and they had a problem, and the Crimean spouse left Japan for Crimea with the kids, and the Japanese spouse wishes to have the kids returned on the basis of this convention. What can this Japanese spouse do? Well, he or she has to apply to Japanese authority, Ministry of Justice, Ministry of Foreign Affairs. That ministry has to get in touch with the central authority, which Moscow or Kiev. since Japan does not recognize the incorporation of Crimea into Russia, probably the Japanese government wishes to get in touch with the Kiev, which is practically meaningless in this case, right? Then, is it possible to get in touch with Moscow? In this case, you recognize that this treaty applies within its territory, which means that Japan recognizes that the treaty applies in Crimea, which is a part of Russian territory. Doesn't mean that? Or is it possible to interpret this term within their territories as meaning the part of land over which a state is exercising its de facto authority or effective authority? I think this rather acrobatic interpretation is not absolutely impossible, because this isn't a treaty which protects which protects the lives of the human person. I mean, the human beings. It's up to the object and the purpose of that treaty. But things becomes more complicated when it comes to for example, the prompt release under the United Nations Convention on the Law of the Sea. Suppose that a ship of a country which is a party to the United Nations Convention on the Law of the Sea got arrested in the exclusive economic zone off the coast of Crimea by the Russian authorities. Is it possible that the authorities of the flag state apply this article or this institution prompt release? I think that's not really possible because of this clear wording of this treaty. The Article 73 provides that the coastal state may, in the exercise of its sovereign rights, right? Therefore, the Russian authorities, on the basis of its understanding, exercise the sovereign authority by arresting the ships which was probably being engaged in the illegal fishing, which in itself has nothing wrong if the Crimea is part of the Russian territory. In this case, if the flag state applies, try to apply this article or institution of the regime of prompt release against Russia, I think that implies by necessity the recognition of sovereign rights of the Russian authorities. Next example is also mentioned. This was also mentioned by Stefan Oeter. Investment treaties. This is, I quoted the Norway-Russia bilateral investment treaties, which was concluded in 1995. It has a very general article, fair and equitable treatment clause in its Article 3. It provides that each contracting party will accord in its territory for the investment made by the investors of the other contracting party fair and equitable treatment. Well, we may be able to try again. Give it a try to make a very acrobatic interpretation that, so that this term territory means a part of land which, over which a certain power exercises the de facto power. But this treaty is not a human rights treaty. This treaty is not a treaty about child abduction. Of course, this is an investment treaty which protects investments and investors, but for what? For what purposes? If you look at the preamble, you will notice that this treaty was concluded to develop the economic cooperation between the two states. Therefore, for the development of the economic relationship or economic development of the states, this treaty was concluded. So, the investor protection is just a means, just a method. So the purpose of the treaty is the development of the relations between the states. Therefore, I do not really think that if Norway does not recognize the annexation of Crimea into Russia, Norwegian investor can invoke this treaty within Crimea. But this causes lots of practical problems. If Norwegian investor, despite the position of the Norwegian government, tries to apply this treaty and institute an arbitration against Russia over what has happened in Crimea, and suppose that the arbitral tribunal renders a decision arbitral award, ordering the Russian government to pay compensation, right? The Russian government may be happy about that because the arbitral tribunal recognizes that the Crimea is a part of a territory of Russia in the sense of this, for the purposes of this treaty. What would happen? The investor has to enforce that arbitral award. Where? Probably in France, probably in the UK, probably in wherever, in Switzerland. Then what would the French court, let's say that the investor tried to enforce the arbitral award in Paris. What would the Paris court have to do? The France does not recognize the incorporation of Crimea into Russia. Therefore, from French point of view, this does not constitute, the Norwegian investors are not covered by this treaty. Therefore, the French court may be obliged to refuse to enforce this arbitral award. This kind of practical questions will be, we will see this kind of problems in the near future. Well, I have many other examples, but given the time, I think I'd better stop here. And thank you very much indeed.
Thank you very much. Perfectly done, Mr. Hamamoto. We are going to keep up with our plans. And now we turn to my dear colleague Przemysław Saganek, who is assistant professor at the Institute of Legal Studies. He is author of books on unilateral acts of states and public international law, and on division of powers between European communities, a different name today, and their members, and many other publications. And I give the floor to you. Please start, Przemek.
Thank you very much. My idea was to speak something about the Polish attitude to the obligation, as we believe, to non-recognition, or if somebody prefers, to the policy of non-recognition, and our domestic law implications of how it works. I was lucky enough to speaking as the last speaker as regards those ordinary ones. We have still two co-speakers with due respect to them. So many aspects were already said. What I would like to say is that whatever the origins of the non-recognition, we can discuss whether Stimson doctrine was an expression of obligation or not. Perhaps at the beginning it was not. But it does not change the fact that for many states there is an obligation of non-recognition, especially with respect to illegal annexation. We have no doubt, despite all words that were said, they were just words. Everybody of us knows that what happened was illegal, and nobody in this room would accept something like this with respect to his or her own state. This is beyond any doubt. Whatever the political implications and conditions in different countries, I know that not every speaker can say what he or she wants to say. As regards Poland, so we feel that we are under an obligation not to recognize, and it means, in fact, three matters. First, we feel an obligation to avoid an express recognition. Secondly, we feel an obligation to avoid implied recognition. And thirdly, we feel that we must be very careful as regards the references of our law to Russian acts and Russian laws issued or effected with respect to Crimea. Let us start with the first element, because it is obvious. There is an obligation. If there is an obligation not to recognize, there is a prohibition of express recognition. And with respect to this, we can just compare it to the provision of criminal laws of many states, according to which a positive assessment of a crime is a crime itself. Of course, I don't want to introduce into this debate the world of international crimes. This is not my intention. This is just an association with domestic law, which will be present in many other aspects of my presentation. Secondly, there is an obligation to avoid implied recognition. And this is something that requires great carefulness of our organs. And I think that many aspects were already said. Because on the one hand, we must be, as I said, we must take care not to avoid any statements in treaties or any behaviors which could be treated as implied recognition. Secondly, we cannot assume that there will be no contacts with Russia and no contacts with respect to what is going on in Crimea. Perhaps Crimea is not the greatest peninsula in the world, but all the same, this is quite a considerable place with many interests, with many people possibly being engaged, and that is why it is important what forms of contact imply recognition and which do not. And as I said, as was said by the previous speakers, we can say that it would be impossible to say that any address to Russia with respect to what is going on in Crimea could be seen as an implied recognition. I think that what was not said was the question of consular relations. So I think it would be good to say something about this element, because of course there is no problem of any diplomatic relations. There is no attempt to say that there is an independent state of Crimea. Crimea is believed by Russia to be an integral part of Russia. From the perspective of non-recognizing states, including Poland, it is an integral part of Ukraine. In fact, before the annexation, there was a Polish consular office in the Crimea, and of course the question is the following: what implies recognition and what is not, as regards matters connected with consular matters. And we can say that there is no doubt that the preservation of previous consular officers does not imply recognition. What about the establishment of a new consular office, or what about a formal agreement according to which Crimea would be a part of another, would be a part of an area of another consulate with the Russian exequatur? In fact, in the legal literature, we have many references according to which a request for exequatur is believed to be a form of recognition of a new state or a new government. The question is whether we can extend this conclusion to recognition of annexation. And in my opinion, we cannot. Of course, our idea is that it is necessary, it is useful to avoid the establishment of such consular relationships as long as possible. But different states could have different interests. And because of that, if it happens that it is necessary to somehow establish consular relations to regularize them with respect to Crimea, I think it does not necessarily imply recognition. And as regards other forms, of course, they were already mentioned by the previous speakers. So let me refer to the problem connected with recognition of acts and recognition of laws. Because, of course, there are many reasons. There are many reasons for that. And of course, the basic underlying question is: can we say that we deny recognition of annexation if we recognize something that was effected by Russia in Crimea? And in fact, when dealing with this question, one can really wonder whether we are still within public international law, or are we just entering domestic laws of many states, or maybe are we just going to refer to domestic case law? In fact, the reference to this domestic case law is inevitable. And in fact, the majority of the cases were issued in the context of non-recognition of governments. In fact, a very long non-recognition of the Soviet government resulted in the abundant case law concerning the effects of non-recognition. But I think that they are quite interesting and maybe inspiring. Of course, not all of them could be applied directly. But the question for lawyer: why not apply them by analogy? The basic problem is that those cases go into two opposing directions. Some of them are based upon the quite logical assumption, and I think that what is the most in common with logic says that if we don't recognize annexation, we don't recognize any Russian acts or any Russian laws connected with Crimea. And I think that this logical conclusion could find support in many cases The leading one was of course, the famous Luther versus Hague case. It had to deal with nationalization decrees, so I know, I have the feeling that the similarities, besides the similarities, there are also differences. But I think that the underlying idea is worth recalling here. In this case, the discussion was who is the owner of products which were nationalized by the government, by the Soviet government, which was not recognized at the moment of the issuing of the judgment of the first instance. And the British court deciding in the case said, if we don't recognize if we didn't recognize the Soviet government, we don't recognize nationalization decrees of the Soviet regime. So the owner is the previous owner, the owner who was before nationalization. In fact, the case is quite special because before the judgment in the second instance, recognition was given by the United Kingdom government, and the second judgment was just the opposite. Another leading case just from America was famous Petrogradzki Międzynarodny Komerczanski Bank versus National City Bank of New York. In this case, the plaintiff was Petrogradzki Międzynarodny Komerczanski Bank, the bank which, the Russian bank, which according to the Soviet decrees was nationalized, so was no longer in existence. The question was whether as the United States at the time did not recognize the Soviet government, that bank exists according to the law or not. The judgment in this case was that yes, it exists. There is no recognition of the government, so there is no recognition of extraterritorial effects of those decrees. Somebody could say, well, it does not matter. Those are cases connected with governments, but we have another case just connected with annexation of Estonia, and the case was very similar. In 1940s, Estonia was illegally annexed by the Soviet Union. And in 1947, one of the Estonian pre-annexation firms demanded its property before the American court. And the ruling of the court was the following. We don't recognize the annexation, so from our perspective, the Estonian firm is still in existence. But this is just one light of the story. Let us forget about nationalization decrees. There were some other elements. And in fact, some courts in Alexandria did not recognize divorce judgments. So, and now this is something not very nice from the perspective of a normal person, because, of course, everybody has his or her own opinion on divorces, but it is not nice to hear from a foreign court that somebody is still in marriage. So it was just an extreme. In fact, there was a strong conscience of this element, and we can find another side of this story. So there are many cases in which the courts decided to apply the rules of an unrecognized regime. And references to them were already made. There is no sense for me to mention all of them, but maybe just one exception. It was a very old case coming after the American War of Secession, case Texas versus White. And it was in this case that the court said that despite the non-recognition, many elements of unrecognized regime must be taken into consideration. And the court, including among them such items as births, deaths, transactions connected with marriage, inheritance, and transportation, as well as protection of property. So, in fact, we have just two opposing lines of judgments. One of them says, if we don't recognize the change, in this case the annexation, we don't recognize any acts, any documents issued by the non-recognized regime. The other says, well, we must make some exception. Of course, the question is, why is it important from the perspective of public international law? The answer is, yes, it is important because if we accept some documents, what is the value of non-recognition? And I think that not much time is left for me, so please let me refer just to three provisions of the Polish law dealing with which could be applicable in the case of several acts or several transactions connected with Crimea. Let us have a look at recognition of judgments of Russian courts effected in Crimea. We must have reference to the Polish Code of Civil Procedure, which says that a judgment could be recognized or otherwise could not be recognized if this judgment is not definitive in the state in which it was issued. And let us imagine that we have a judgment of a Russian court in Crimea. Is it definitive in the state in which it was issued? Evidently not. Why? Because this state is Ukraine. So Russian judgment is evidently not definitive in Ukraine. From the perspective of the Polish Code of Civil Procedure, we have a fundamental obstacle with respect to applying Russian judgments, including judgments of divorce, it must be said. Secondly, let us imagine that there is a document issued by Russian officials with respect to Crimea. Is it an official act from the perspective of the Polish Civil Code? Evidently not. Why? Because Russian authorities have no power to effect transactions with respect to Crimea. It is just Ukrainian organs that have that power. So in this situation, from the perspective of logic, it is very good. But what if somebody claims that he's born or his father is dead? In fact, the picture is not that cruel to normal people, because what we have to do is the possibility of treating birth or death certificates just as private documents or as any evidence that could be taken into consideration by the court. But we must say that the policy of non-recognition could be connected with important problems for normal people, and it requires some kind of consideration. Who are we actually harming? Isn't it so that this danger is too big to take upon itself? What should actually be done with respect to this internal part of non-recognition? And I would say that this is not the aim of non-recognition policy to harm normal people. And as the International Court of Justice in the Namibia advisory opinion said, we should do as much as possible with respect to avoiding problems for people. All the same, we think that non-recognition is the best service that can be done to international community as such and to people in the longer perspective. And that is why all the same, we must count with several problems connected with non-recognition, but the aim, I think, is the aim of preserving peace and preserving borders. I think it is the price which is worth some problems. Thank you very much.
Thank you very much, Saganek. And now we thought we should continue with the discussants, and I'd like to give the floor very quickly to Mr. Ilya Nuzov from Geneva, and maybe you can add a few words on your person, which gives you some extra seconds, and then you'll have 10 minutes to give your talk. Thank you. Oh, micro?
Yeah.
Thank you very much. Thank you, first of all, to the organizers of this great conference for extending the invitation. As was stated, my name is Ilya Nuzov. I'll let you guess what nationality I am, but I'm based in Geneva, and I'm a teaching assistant at the Geneva Academy of International Humanitarian Law and Human Rights, and a PhD candidate at the University of Geneva with a specialization in transitional justice in the post-Soviet space. I'm sorry to disappoint those of you who expect to hear more about non-recognition. In fact, I'm going to speak to recognition very much, and in fact, a ratification by the Russian Constitutional Court, essentially a ratification by the Russian Constitutional Court of what the court referred to itself as the treaty between Russian Federation and Crimea, incorporating Crimea into the Russian Federation. But of course, it touches on questions of recognition indirectly. Now, the decision came out on March 19, 2014, and it was done pursuant to a national scheme to ratification of international treaties. Before it becomes operative law upon final ratification by the Duma, the Constitutional Court has to see if the treaty complies with the Constitution of Russian Federation, which of course is, references international law, and I want to talk about this national scheme for implementation of international treaty. So, by way of background, most of the facts have been already brought up here by previous discussants yesterday and today, but I think it's important to reiterate some of them, such as on March 11th, the overtaken parliament, Crimean parliament, issued a declaration which essentially proclaimed that upon the results of a referendum to be held several days later, the Republic of Crimea will be declared a sovereign and independent state. And I'll explain, you'll see the significance of this in the coming minutes. Of course, very swiftly, on March 17th, President Putin said that we recognize, officially recognize the Republic of Crimea as an independent and sovereign state, which was followed by the conclusion of the so-called treaty on March 18th, and then finally on March 19th, the Constitutional Court issued the decision that is the subject of my presentation. Now, so what was actually the court required to do? Well, it was petitioned by the president to review the Crimea Treaty, ostensibly in order to conform to the national scheme of implementation of international treaty into domestic law. So what is the framework for this under Russian law? And of course it's governed first and foremost by the Constitution, which states in Article 125 that the addition of new subjects into the folds of Russian Federation is to be effected in accordance with Russian constitutional law. So what does the federal constitutional laws. So what do the federal laws have to say about that is the obvious question. And what I'll refer to briefly is the incorporation law of 2001 sets out the procedure for affecting this transaction. And Article 4 of the same, in fact, authorizes the incorporation of a foreign state, and this is, now you see the connection between the declaration of being a state and how it's relevant here. So it authorizes incorporation of a state into Russia and requires this admission be effected by way of an international treaty concluded between Russia and a foreign state. So now we can actually address a little bit the question of, well, is there a capacity even of Russia to conclude a treaty with Crimea, implying that the issue of whether at that time Crimea constituted a state, which was of course touched upon by colleagues yesterday, but I think it's still a question that's open. In fact, if we consider the constitutive theory of recognition, perhaps it's plausible. So maybe that's a question I address to you. And then, so subsequent to the conclusion of the treaty, the president then petitions, he must petition the Constitutional Court to review the treaty for constitutionality. And how does the court do that? Well, it does it in accordance with the another federal constitutional law on the Constitutional Court of the Russian Federation, which is fair to say is sort of like a charter of the Constitutional Court. This is how it operates. And it gives the Constitutional Court competence to scrutinize signed but unratified treaties before they come into full effect. Now, so then, what was the applicable law then that the Constitutional Court has to consider? Well, obviously it's the Constitution, it's the Constitutional Court. So Article 15, paragraph 4, very important provision, provides for the incorporation of treaties into domestic law. And in fact, it contains a hierarchy provision which states that if a treaty concluded by Russia conflicts with domestic regulation, then the treaty prevails. And the other significant piece of legislation, of course, again, is the incorporation law, Article 2 of which states that the incorporation of new subjects is to be carried out in accordance with the Constitution again. The treaties concluded by Russia the incorporation law itself and other federal constitutional laws concerning the incorporation of new subjects. Okay, so we have a fairly elaborate but very unambiguous framework which stresses the significance of international law. In fact, if you look at previous decisions of the Constitutional Court itself, in the 1995 decision on Chechnya, which is worth quoting, I think, pursuant to the tenets of the rule of law, well, I'll let you read it yourself for the to save time. But obviously, there's a great reliance on the international law by the Constitutional Court itself, and it declares that the agents are bound. The agents of the state are bound not only by domestic, but indeed by international law. So what does the court do after all this? Well, again, I refer back to the law on the Constitutional Court. Article 86 prescribes exactly what it should consider in evaluating or verifying the treaty for constitutionality. So the first thing it should look at is the substance of the norm, the form of enactment, the agreement of the treaty, the procedure for their signing, conclusion, adoption, and so forth. So I think it's fairly obvious that the court had to consider the treaty and the contents of the treaty. And in fact, in the decision itself, the court admits to having to do this. Okay, I apologize for this. It's not a translated excerpt from the court decision, but I could tell you quickly that it states at the end, it sets out the procedure for conducting the evaluation, and then at the end it says, indeed, as a consequence, the court has to do it, has to consider the treaty and the substance of the treaty in its entirety. So very quickly, the only reference to international law in the court's decision is to Article 25 of the VCLT when it considers, so it goes by provision, when it considers the first provision of the treaty itself, which states that the treaty takes effect immediately upon the signature of the president prior to ratification. The court goes to Article 25 of VCLT and states that this is fine according to VCLT, which provides for the provisional implementation of treaties, if you recall. And that's the only reference to international law. So, it states that by virtue of the signature being right, the treaty complies with the procedural, all the procedural aspects of how it was concluded, signed, and so forth. So by extending this logic to how the treaty was concluded, the court should have at least referenced Article 52 of the VCLT, which states that treaties concluded as the result of violation of the use of force of the UN Charter, of course, are void. And now we go back to the discussions we had yesterday, and we come to a very obvious conclusion. I think that even considering this simple, this one provision, I think it will invalidate the treaty as a whole, and not to mention the other treaties previously entered into by Russia and Ukraine, which would also conflict and impair those treaty obligations. And if I just make one personal note, I'm staying here with my uncle in Warsaw, and he told me that upon the return of Crimea, he was so touched that he had tears of joy rolling down his face. And unfortunately, I cannot share his jubilation because while it's very nice to go to holiday to Crimea, I ask you. If we consider just this decision as another evidence of the state of the rule of law in Russia, I think that this outweighs the benefits gained by having a holiday in Crimea. Thank you very much.
So thank you, Mr. Nuzov. We were not disappointed at all by the selection of your issues, because I think we can't really understand the concept of non-recognition without going into the details or some details of recognition. So thank you very much. And I turn now to Dr. Wiliam Worster from, please.
Okay, thank you very much. I'm very awkwardly going to walk around here because I need to be able to see my slides.
Be careful.
I'll get lost and you'll be lost too.
Yeah. And please tell a few words on your person, because the lack of time should not corrupt politeness.
Yes, okay. My name is Wiliam Worster. I'm assistant professor at the Hague University of Applied Sciences in the Netherlands. am at a significant, is this working as well? I'm at a, maybe I can, yeah. I'm at a significant disadvantage because I feel like this topic has basically been completely exhausted by all the previous speakers, and I have almost nothing more to add. All I want to do is just play with a thought experiment about what kind of a solution we might have for this kind of situation, thinking about these issues of recognition and non-recognition. We're at an awkward situation. We have, on the one hand, this obligation not to recognize the situation. But then we have a very entrenched Russian position. And they have made a number of claims for legal basis, much of which I think the majority view here is that they're bogus. But that there is this also, I think, an existential threat that Russia feels, this idea that they need to control the Black Sea and the Navy that's there, and without that, that's sort of maybe a threat to their very existence. So how do we, on the one hand, deal with this idea and yet the obligation not to recognize at the same time? And the problem is it's coming down to an all or nothing debate. Because we say, Russia says there is no discussion about this. And then all the lawyers say, well, you can't recognize the situation. And so then everybody sort of shrugs. We don't know what to do, and we need a legal solution coming out of this. The way I'm going to think about this, the thought experiment I'm going to have about this, is to look at quasi-states, quasi-persons that we have in the international legal order. What is their nature in this recognition, non-recognition, personality, non-personality debate, and to see if we can learn something from that we can then use in this kind of a situation. So when we look at legal persons, if it's a state that we're talking about, the majority view is that a state is an objective legal person, right? Ergo omnes. It exists as per all other entities. Of course, there are dissents from that, Kelsen being, I think, the most important, that you could have a kind of subjective nature. So it's a potential idea that's out there. If we look at other legal persons, international organizations, corporations, NGOs, we see all these different instances where they are sometimes treated as a person, sometimes not treated as a person, a kind of mixed practice. So I think we could contemplate this as an idea. And I'm sorry I'm moving very fast through the slides because of time. What is this possibility then for having a relative personality for quasi-states? Well, sometimes what we have is an entity that might exist as a state for purposes of a particular international organization or a particular, the organization when it engages with the state might define statehood in a particular way. So they might say only states can be members, but then maybe they interpret that in a very liberal way. We've seen this with the Palestinian attempt to join the ICC, for example, but it also exists before the UN as well as a number of other entities. Then we see treaty regimes. So within some treaty regimes, you must be a state to enter into this treaty. Occasionally that's defined according to what we call the Vienna formulation, saying, are you a member of the UN essentially? But some treaty regimes are interpreted very liberally, saying whether something is a state or is not a state is something that can be defined just for purposes of that particular treaty. Seems to be the way that we're going to go with the ICC and Palestine. In addition, some treaty regimes are open specifically not only to states, but maybe even sub-entities of a state, which is a bit of a curious idea, that within maybe a federal organization, you might have one entity being able to join a treaty independently or separately from the rest of the body. Then we have the Namibia exception, which I'm not going to go into detail about because I think it's been completely discussed as well. So a whole number of considerations for humanity, human rights, international humanitarian law, those kinds of things. The one thing I didn't really hear discussed much was the issue of nationality, what nationality people are going to get. But again, unless we have a sort of use solely kind of situation, that's maybe not the most important consideration there. The use of force is a weird emerging area when it comes to quasi-states. Normally we think of a quasi-state, whichever body it's legally part of, it will be protected from the international use of force from external actors. But it would not be protected from the use of force by its mother state. It doesn't make any sense because the mother state is meant to protect law and order. But we're starting to see an interesting trend, and this was particularly evident in the International Fact-Finding Mission on the conflict in Georgia, when they looked at these stable entities, South Ossetia, Abkhazia, and whether or not they would be protected by the prohibition on the use of force, not just from Russia, but also from Georgia. And they concluded that they would, which I thought was a pretty remarkable conclusion. Maybe not completely unprecedented, because I saw the situation of Hyderabad many years ago before the UN, but maybe we can begin to see these kind of quasi-entities as being protected if they're somewhat stabilized from the use of force. Those are sort of factual scenarios or functional areas where we might say, let's regard this entity, because of a particular function that it's serving, as having maybe a personality or a certain kind of competence. And then there are other structural situations. So in the colonialism situation, for example, we had a long history of debate. Are these entities their own entities who have their sovereignty suspended because of domination, alien domination, or can they operate independently of that? And very mixed practice, which evolved over time. Even now, we have very curious situations like New Caledonia and some others where it's not clear, is it an independent country, not an independent country? Internationalized territories are the same thing. This is sort of the successor to a lot of first we had colonialism, then we have sort of trust territories, and now we have internationalization. So when, say, the UN is administering a territory, to what degree is that entity independent? And can it join on its own other international organizations or things like that? I thought one of the most interesting situations was in Kosovo was the relationship between the Kosovar authorities and UNMIK, and who was actually in charge of the territory for all these different competences that they had to discharge. Entities in transition is another category, something like a Palestine or similar types of categories where something is moving from being maybe a colonial situation, moving into independent situation, but there's no sort of definitive moment where that's really happening, or it's a long evolutionary process. And we have this questionable time. Is it an independent entity? Is it not an independent entity? And how do we deal with that on a functional basis? This is the China-Taiwan situation, where you have two entities essentially saying we're part of the same state, and yet functionally being treated as if they're separate independent countries. Succession movements, again, same thing. We have centralized organization, one movement trying to withdraw from it. On a functional basis, we might be able to contemplate that entity as having some distinct personality or some distinct status away from the mother entity. So again, sort of just a thought experiment, thinking about, given this situation, this entrenched situation where we can't recognize, but we're pretty confident that the occupying power is not going to retreat, how do we move forward legally? And drawing from all of this history, I came up with a variety of just different ideas. Could we contemplate the notion of a shared sovereignty situation? Could we contemplate the notion of a maybe condominium, which is something that's sort of going out of international practice, but maybe we need to revive it? Can we contemplate a situation where we have title to sovereignty in one entity, and yet it's administered by a different one? Can we contemplate having, say, all of Ukraine being able to exclude this one territory from its treaty relationships? So, for example, if Ukraine wants to move closer to NATO, closer to the EU, but exclude Crimea from doing that, while at the same time still being sovereign over it. Whole variety of different ideas. And like I said, I feel like the topic has been beaten to death, but I just wanted to give some ideas on thinking about what the world looks like tomorrow. Thank you.